Hey everyone, this is Aditi and we are watching Legal Bites. Our today's topic of discussion is Ubi jus ibi remedium. In this video, I'll be looking at the introduction to Ubi jus ibi remedium, meaning of Ubi jus ibi remedium, what are the essentials of Ubi jus ibi remedium, and limitations of Ubi jus ibi remedium, and at last but not the least, I'll be talking about legal precedents. Now let's start our video. Coming to our first topic, that is introduction to Ubi jus ibi remedium. As we all know, rights and duties are correlated to each other. Every right has a corresponding duty attached to it. If the state provides us with a certain right, it also constitutes a corresponding duty to it. That is duty not to violate others' right. Therefore, if a right which is recognized by the state or by the law is violated, the state provides a remedy. Now coming to the meaning of Ubi jus ibi remedium. Ubi jus ibi remedium is a Latin maxim which means where there is a right, there is a remedy. This maxim can be expressed as no person will endure any wrong without a remedy. The fundamental principles of this maxim are jus and remedium. Jus means legal authority to do or to demand something, whereas remedium may be defined as the right of a person to approach the court of law for the wrongs done to him in order to claim recovery for the violation of his rights. Article 8 of the Universal Declaration of Human Rights proclaims that everyone has the right to a good remedy by the competent national tribunals for the acts violating his fundamental rights which is granted to him by the Constitution or by any other law. Now coming to the essentials of Ubi jus ibi remedium. Our first essential is this maxim is applied only in a case where legal rights exist. Our second essential is a wrongful act must have been done which violates the legal rights of a person resulting in legal injury. Our third essential is this maxim is applied only when sufficient relief has not been provided by the courts to the person who sustained injury. Now coming to limitations of Ubi jus ibi remedium. Our first limitation is this maxim does not apply to cases where moral and political wrongs are involved as they are not actionable. Our second limitation is this maxim does not apply to cases where no legal damage has been caused to a person. Our third limitation is this maxim does not apply to cases of marriage vows and personal commitments because all these are relations made without consideration and are based on fiduciary. Our fourth limitation is this maxim does not apply to public nuisance unless and until the plaintiff shows that he has sustained more injury than other members or people of the society. Now coming to legal precedents. Our first leading case law is Sardar Amarjit Singh Kalra versus Pramod Gupta and others. In this case, the court held that the principle of Ubi jus ibi remedium is recognized as the basic principle of the law. The Supreme Court further held that it is the duty of the courts to protect and maintain the rights of parties and help them instead of denying them relief. Our next leading case law is Bhim Singh versus State of Jammu and Kashmir. What happened in this case was the plaintiff was an MLA from the Jammu Kashmir Legislative Assembly. One fine day, while he was going to attend a parliamentary session where there was also a voting session in which his vote was very crucial, he was then stopped and arrested by some police officers. And not only this, he was also not presented before the magistrate for 4 days and was kept in some hidden place. As his right to vote was infringed along with Article 21 of the Indian Constitution, he moved to the Supreme Court by filing a writ petition under Article 32 of the Indian Constitution. The Supreme Court held that as he was detained unlawfully and Article 21 of the Indian Constitution has been deprived of him with many other fundamental rights. He was then awarded with Rs 50,000 as a compensation on account of the violation of his fundamental rights. Our next leading case law is Ashby versus White. What happened in this case was the plaintiff was a qualified voter, yet he was detained from casting his vote in a parliamentary session by the defendant, Mr. White, who was a police officer. As his right to vote was infringed, the plaintiff filed a suit against the defendant and asked for a certain amount as compensation for the damages caused to him. The court held in this case that to restrain a person from casting his vote is a civil wrong and the person has complete right to ask for remedy. The principle of Ubi jus ibi remedium was applied in this case and certain amount was awarded to the plaintiff as a compensation. Hey everyone, if you find this video useful, do like, share and comment. We'll meet with the next video very soon. Till then, bye bye. Thank you.